Welcome back. In May 2023, the new Procurement Bill was introduced in Parliament. The bill seeks to regulate public procurement, including preferential procurement. It also gives effect to the entirety of Section 217 of the Constitution. For more on this, let's bring in Ryan Brunette from the Public Affairs Research Institute. Mr. Brunette, thank you so much for your time on Newsnight this evening. Can you tell us first off, why is simplifying the legal framework of this bill such an important step towards improving the public procurement system as a whole?
Yeah, I mean, it's a complicated question, but basically, the way in which the public procurement system has elaborated over the last 15, 20 years, there's basically a multitude of public authorities that regulate the space. They've produced a wide range of laws. So there's something like 22 statutes that directly regulate procurement. They've in terms of subordinate legislation, we have around over 100 different instruments on last time I counted, and that makes it quite difficult for people to kind of locate the legal principles that govern any particular procurement process. This means decision making becomes costly. Often there's confused and overcomplicated processes. It opens processes up to legal challenge, and yeah, just generally the complexity creates lots of room for administrative dysfunction, corruption, and so on.
So in the confusion, it's easy for corruption to also get lost. Let's talk briefly about what are some of the remaining challenges, and there are a number of those relating to definitions within the bill. Perhaps you can give some clarity on that.
Yeah, so ultimately, this all kind of goes back to, as you mentioned, Section 217 of the Constitution, which sets up. I mean, it's quite a ultimately opaque clause of the Constitution. There's quite a bit of difficulty around legal interpretation. But ultimately, what the clause says is that procurement in South Africa must proceed through a system which is fair, equitable, transparent, competitive, and cost-effective. There's provision for preferential procurement, what we call preferential procurement, which is your black economic empowerment and so on. And then there's a third clause which requires preferential procurement, as we currently call it, to be elaborated through a national legislative framework. Now, the bill, in a way, follows kind of like existing practice in, we would argue, kind of misinterpreting what exactly these terms mean, right? So, for example, in kind of ordinary English and also in kind of international procurement practice, a preference is just one kind of measure that's used to advance certain policy goals, right? So a preference is a margin of advantage which is given to particular bidders that fit into certain categories. The way we use the term in our law, but also in the bill, expands the definition of the term quite considerably. So we call not only preferences, but also stuff like set-asides, where only particular categories of people can bid for contracts. Stuff like product specifications, which we use for kind of local content. Only goods that have a certain amount of local production and content in them can be bought, and so on. We call all of this preferential procurement. Now that down the line may well create serious kind of like legal problems. Should these things kind of come up in court, they could be challenged. It could be challenged to say, local content regulation sits outside the Act, and so on. So it's a fairly complicated issue, but what we think is that the bill really needs to do a very precise job of grounding statute on the kind of Constitution, and currently it's a little bit vague, confused, which creates problems in terms of how the system evolves down the line.
There's also been some criticism about the fact that this bill gives National Treasury and the Public Procurement Office far too many lawmaking powers to fill in current blanks, and too much power broadly. Is that not simply opening the door to more corruption on possibly an even grander scale?
I mean, the simple answer to that is that we kind of don't know, right? It's true that the bill gives a wide range of lawmaking powers to the executive, to the National Treasury, to the minister, and so on. This is problematic for a whole range of reasons. You kind of lose procedural rigor in legislative drafting. There's greater potential for kind of like for subordinate law to become detached from the Constitution, and so there's a risk of kind of drift into unconstitutionality. There's also, renewed potential for legal complexity, fragmentation, incoherence, and associated, operational rigidities and disruptions. There's also, when you're passing subordinate legislation, there might not be adequate consideration of its impact on rights, with potential for kind of associated litigation and so on. We see this especially in the kind of preferential procurement clauses of the bill, which throw very kind of open-ended, broad powers to procuring institutions, so to ordinary government departments and so on, local governments, etc. And it doesn't really kind of guide these procuring institutions regarding how to exercise these powers. So these institutions can, they can construct their procurement systems in such a way that they could ensure that only bidders that are based in particular geographical areas bid on tenders, right? So this is problematic because there's a whole range of ways in which this could kind of drift away from the constitutional principles of competitiveness, fairness, and so on, cost effectiveness, and so arguably that kind of falls foul of the Constitution already, because what the Constitution requires, as I've said, is a national legislative framework. Right, a framework is more than just any old law. It's something that guides and constrains the ways in which powers can be exercised. And the bill, as it currently stands, does very little of that. And that has large potential for new problems to emerge. Lots of space may be created for corruption and just for general mismanagement, maladministration, and so on. So that ought to be cleared up before this thing gets out of Parliament. Otherwise, there's going to be very likely large problems down the line.
Apart from needing a very solid framework that clears up all that interpretative complexities, we also need a bill that makes adequate provision for transparency, oversight, accountability mechanisms, and for adequate enforcement protocols. If we don't enforce the bill, it almost becomes null and void once again, and we sit pretty much in the same situation we are in now. Do you find that that's woven into the bill in its current form?
To some extent, it's there. So, what the bill does do is it has a range of provisions that provide for more transparency than we've had in the past, information technology to be kind of drawn into the procurement processes, into the system. There's one clause that has kind of generated a bit of consternation within civil society and more broadly, which is, and I'm not sure whether this is government's intention. It might just be problematic drafting. But there's a clause that some people have come to see as a kind of secrecy clause. The background and intention behind the clause is that it's supposed to create space for kind of civil society, for media, for the general public, to observe procurement processes, to monitor procurement processes more closely. So, sit in bid committee meetings, and so on and so forth. There's a range of things you can do with that kind of provision. But what's happened recently is that the bill included a kind of limiting clause on that provision, which basically gives the government the power to decide which procurement processes are opened up to observation in this kind of way. The way that should work is that, there's a whole lot of reasons why you might want to close up procurement processes legitimately. For example, people that get access might be abusing their rights to access and so on. The problem on the other side is that the way the clause is drafted is that it may impact on broader kind of transparency rights in the bill, but also in other laws. That clause needs to be drafted very carefully in the sense that whatever limitations are provided there are only limitations in terms of observation, deeper kinds of monitoring, that they're not limitations to broader transparency rights, and that's not quite there yet. And so, while we think legally, if this were to go to court, that clause wouldn't hold up if it was used to kind of cut down on transparency rights. But there's still, potential for abuse, and we don't want to have to go to court and so on. More broadly, in terms of like enforcement, a lot of it depends on the broader system, right? So the Public Procurement Bill can't do everything. The National Prosecuting Authority, the broader kind of like criminal justice system and so on needs to play its role. What the bill does is it does expand some kind of like powers for what will be the Public Procurement Office to investigate, to subpoena, that sort of thing. And yeah, so I mean, I would argue, the bill's relatively strong on that side, but there's still kind of some confusions to clear up. There's still some work to do.
There is still quite a lot of work to do before this gets decided on, still open for public participation, for comment in Parliament. So we're going to have a lot more of these discussions to try and unpack the minutiae and the details of this bill to try and get to the bottom of what still needs to be worked on. But thank you very much for your input. That was Ryan Brunette from the Public Affairs Research Institute.